Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering companies panic as lawsuits take out DEI, diversity, equity, and inclusion. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from Bloomberg, Wall Street's DEI retreat has officially begun. Programs once meant for people of color and women are now open to all. From Bloomberg, business is booming for DEI lawyers as corporate America asks, what's legal? Lawyers advise against race-conscious hiring or pay practices. Muldrow vs. City of St. Louis case being watched for next steps. The Supreme Court has not issued their decision yet, but they have already heard the arguments from the plaintiff and the defendant. And it looks like the Supreme Court is going to find for the plaintiff. If the Supreme Court goes the way it looks like it's going to go on this, it will be very damaging for discriminatory employers. It could mean the absolute end of DEI, but as it's going right now, it looks like we're getting very close to the end of DEI. Employers are making changes because they're getting sued and they're afraid of even more lawsuits happening. Here's another example, a lawsuit that just got filed. From The Hollywood Reporter, CBS sued by SEAL Team Scribe over alleged racial quotas for hiring writers. Brian Beneker, a script coordinator on the show who claims heterosexual white men need extra qualifications to be hired on the network shows, is represented by a conservative group founded by Trump administration alum Stephen Miller. And that's this guy. Stephen Miller has made a lot of problems for major companies over their obviously discriminatory and illegal programs. This case he's filed now against CBS is the first major case of its kind against the entertainment company. Disney, we're looking at you. You're going to be next. From Bloomberg, Wall Street's DEI retreat has officially begun. Goldman Sachs Group has made a surprising change to its Possibility Summit for Black college students. It's opened the program to white students. At Bank of America, certain internal programs that used to focus on women and minorities have been broadened to include everyone. And at Bank of New York Mellon, executives are being urged to reconsider hard metrics for workforce diversity. Lose them, lawyers have advised. This is what diversity, equity, and inclusion looks like on Wall Street today. Anxious, fraught, and changing fast. And that's what you want. You want the employers to be very nervous, very concerned, and getting back to hiring people based on merit and stopping it with the discrimination nonsense. From C-suites down, American finance is quietly reassessing its promises to level the playing field. The growing conservative assault on DEI, coupled with pockets of resentment among the white employees, have executives moving to head off accusations of reverse discrimination. It's not just Wall Street. In recent weeks, Zoom Video Communications cut its internal DEI team amid broader layoffs, and Tesla removed language about minority workers from a regulatory filing. The seemingly small changes, lawyerly tweaks, executives call them, are starting to add up to something big. The end of a watershed era for diversity in the U.S. workplace and the start of a new uncertain one. Quote, we're past the peak, said Suba Barry, former head of diversity at Merrill Lynch. Wall Street has long skewed white and male, as it still does. Even an inkling that banks are retreating from DEI has some women and minorities questioning how real promises of change were in the first place. Sure, because these companies make promises that they can't keep, and then people say, well, how come you're not keeping these promises? The answer is, they've got to hire lawyers just to protect themselves from lawsuits because they have to ask themselves questions like, well, okay, is this even legal what we're doing? The executives know it's not legal. I have some experience in business. I've been around the block a few times. I'm not an attorney. I've dealt with a lot of attorneys on a number of different subjects, but it's very apparent and very clear what is and what isn't legal. They know what they've been doing isn't legal, and they know they can't keep doing it. Publicly, executives insist they're as dedicated as ever. Goldman Sachs and other major banks say they remain committed to attracting and promoting people from a range of backgrounds. Privately, however, many acknowledge that the high-profile campaign against DEI, amplified by billionaires including Elon Musk and Bill Ackman, threatens to set back what progress Wall Street has made. It's not progress if it's discrimination and it's illegal. It's great to give everyone an opportunity. They have to earn it based on merit. Otherwise, get the hell out of there and make room for someone else who can do the job and go do something that you're good at doing. It does nobody any benefit to give them opportunities that are inappropriate for them. It doesn't matter what their skin color is. It matters what their ability is. Recruitment programs aimed at women and minorities, a key tool for recruiting diverse talent, are being reworked. In-house affinity groups, specific workforce targets, and even boardroom diversity initiatives are all up for review, executives, consultants, and lawyers say. It's a remarkable turn. Less than 4 years ago, amid lofty talk of a racial reckoning and an inflection point, America's CEOs were vowing to embrace inclusive hiring, promote minorities, and narrow the gender pay gap. Now, after the U.S. Supreme Court rejected affirmative action at the nation's colleges, the legal assault on corporate diversity initiatives is gathering steam. The political right and normal people have villainized DEI from Disney World to Harvard University as an engine of left-wing indoctrination, and the banks don't want to become a target for lawsuits claiming reverse discrimination. When all they've been doing for years now has been reverse discrimination, they're going to still get sued. They're not getting out of any of this. But if they make the changes as quickly as possible and start treating people equally again, when they're hiring them, when they're evaluating them, when they're promoting them, training them, giving them opportunities for additional training. If they start doing the right thing, they'll get in less trouble. Wall Street has made some progress towards diversity over the years. Still, the numbers are sobering. At Goldman Sachs, 3.7% of senior executives in the U.S. are black, according to the bank's most recent report. That figure is about 5% at JP Morgan Chase & Company, and it's 8.7% inside Citigroup. By comparison, black people are about 14% of the overall U.S. population, and yet those statistics represent hard-won improvement for the banks over past years. The percentage of senior black executives and managers at all three fell from 2012 to 2016. You would think these companies would really just want people that are very good at their jobs. I don't know why they have to go tracking everyone's skin color. Bankers and lawyers contend they have little choice but to reframe or pause new diversity initiatives and to get ahead of the blowback and potential litigation, said Valerie Eric Rainford, who oversaw programs to promote black leaders at JP Morgan Chase before leaving the bank in 2019. Bank of New York, for instance, is reconsidering its decision to tie executive compensation to progress on diversity. When they say progress on diversity, that means you need to hire a certain number of people that have a certain skin color. And if you do that, you'll get paid more money. You'll get better opportunities. You'll get better bonuses. And if you don't do that, ultimately, a lot of people are even let go for not discriminating. The lender has also changed the language it uses to describe its diversity and inclusion initiatives in recent months, eliminating references to specific targets around diversity and inclusion, because that language, specific targets, clearly illustrates an illegal quota system. You can't hire people based on quota, based on race, gender, ethnicity, things like that. That is easy lawsuit material. Bank of America has tweaked some DEI programs in the way it talks about them, according to people familiar with the changes. The lender has considered ending some of its mentorship programs because they had achieved their goals and may no longer be needed, one of the people said. JP Morgan's summer fellowships for black undergraduate sophomores is now open to all sophomore students, regardless of background. These mentorship programs are opportunities to move up in a company that are given to employees. Nothing wrong with that. The problem with that is they were limiting it to certain employees of only certain skin colors. Obviously illegal. Similarly, JP Morgan doing these summer fellowships were opportunities to work at, intern at JP Morgan, that they were only offering to certain people of certain skin colors, and they have to hire attorneys to ask those attorneys, hey, what's legal? Can we actually do that? Like, no, you actually know you can't do that. The paper trail they're establishing now by asking attorneys, hey, is it legal? Can we do that? Will help individual executives who might say, hey, I thought it was okay. I really didn't know. They're going to get in. Everyone's going to get in a lot of trouble. I hope it's a lot of trouble, but it will be trouble. It's not as much trouble as they deserve because they've damaged a lot of people's lives with this. People who got promotions that shouldn't have and people who didn't get promotions that should have. They're mismatched in their work positions. At Goldman Sachs, lawyers have advised senior executives to remove references to race and gender in college recruitment programs, according to people familiar with the matter. They've also warned against hosting exclusive events for specific groups such as women and people of color. Spokespeople for BNY Mellon, JP Morgan, and Goldman Sachs said the lenders remain committed to an inclusive workplace with people from diverse backgrounds. A spokesperson for Bank of America said the firm consistently evaluates its initiatives, but has not eliminated any bank-sponsored diversity and inclusion sponsorship programs. One influential Wall Street banker said he's observed that the sway executives in charge of diversity recruitment used to have with decision makers has diminished, Asking for anonymity to describe the recent changes, he said that colleagues who'd been willing in recent years to be open to diverse recruitment are reverting back to the way they were before George Floyd's death. Open to diverse recruitment? Meaning only hiring certain people of certain genders and or skin colors for certain positions? They better cut it out, and they are cutting it out. Rainford, who consults on diversity for companies including financial firms, said one client told her recently that it was wondering whether it needs to pause its diversity programs altogether. Quote, if you didn't have the conviction in the first place, it's easy to say, we're not doing that anymore, she said. For now, her client is sticking with its diversity program, she added. After a couple of major lawsuits, they will all drop them. But no, you shouldn't have conviction to do something illegal, even if you think it's right. If you're a company, you don't get to decide what's right and wrong. We have laws that tell us what's right and wrong. No, companies should not have conviction to support doing illegal activities because it pleases someone's virtue signaling. What's illegal is wrong. Trouble keeps coming. DEI experts are keeping a close eye on a legal drama now unfolding in Miami, where a case has become emblematic of the growing backlash from the right. The Fearless Fund, which makes early investments in companies led by women of color, recently asked a federal appeals court to protect a contest it runs for $20,000 grants for businesses majority owned by Black women. Grants are not investments, grants are not loans, grants are just free money that a business does not have to return. The fund was sued last year by American Alliance for Equal Rights, founded by Edward Blum, the conservative activist behind the Supreme Court case that ended affirmative action in college admissions in June. They claim the fund's grant contest is racially discriminatory. Well, if it's only for Black women, then yes, it discriminates against other women of other colors. It discriminates, obviously, at least against one other gender, if not several genders, depending on what you believe. To me, it's two genders. But yes, that's why you're getting sued. It is discriminatory. The outcome could affect how companies steer funding towards minority-owned startups and businesses. Meanwhile, Stephen Miller, the architect of anti-illegal immigration policies under former President Donald Trump, has emerged as a key figure in preparing a hardline conservative agenda in the event Donald Trump returns to the White House. Miller is bent on eradicating diversity initiatives in business. His advocacy group, America First Legal, has accused dozens of companies of discriminating against white men. Stephen Miller's organization, America First Legal, and he's not even an attorney, but he put together this nonprofit to go after woke corporations. They've gone after many, many companies. Most of what they do are EEOC complaints to the U.S. Equal Employment Commission. They also do lawsuits. But companies they filed complaints against include these: Yum, Twilio, Starbucks, McDonald's, Lyft, Morgan Stanley, Hershey's, Anheuser-Busch, Dick's, BlackRock, Mars, Nordstrom, Alaska Air, Unilever, Kellogg's, Salesforce, Activision, NASCAR, Major League Baseball. It goes on and on. And while these EEOC complaints don't all get resolved, they get a lot of publicity and a lot of attention. Particularly if Trump gets back into the White House, the Department of Justice is going to go after these companies like they've never seen it before. And Stephen Miller will be a huge part of that. But we're at an interesting inflection point, said Anna Duarte McCarthy, former chief executive officer at Citigroup, whose CEO, Jane Fraser, is the only woman to ever lead a major U.S. bank. Yes, many financial companies are pausing and re-examining diversity initiatives, said Duarte McCarthy, who now works as an industry consultant. But most are pressing on, and virtually no one has signaled a full-blown retreat. But we're not suggesting that things stop just because there's this fear factor, she said, but rather take a look. Still, conservative activists and politicians and normal people aren't the only ones challenging DEI. So are some Wall Street workers, albeit far more quietly. The pushback inside the industry is real, according to Barry, the former Merrill executive who now leads DEI advisory firm Ceramount. She's had white women ask her what opportunities their sons will have if Wall Street focuses solely on promoting underrepresented groups. Quote, are they doing it publicly, vocally? Of course not, Barry said. But they're doing it. And when they do it, you have to listen. So what is the answer when white women ask her what opportunities their sons will have if Wall Street focuses solely on promoting underrepresented groups? What's the answer? Oh, well, you have to listen. You have to listen. You have to tell them. Of course, we need to make changes, but they're being forced to make changes because of guys like Stephen Miller and people like you who get the word out. Of course, share the video if you want people to hear more about some of the successes we're having. They want us demoralized. They want Americans to just give up on society and say, well, Obama's agenda, it's taken over. DEI is everywhere. Everything's critical race theory. No, it hasn't. We're under attack. They haven't destroyed America. They're just attacking America. We are under attack. The game is not over, and it's starting to go in our favor. From Bloomberg, businesses booming for DEI lawyers as corporate America asks, what's legal? The furor over corporate diversity, equity, and inclusion programs has turned so explosive that it's never been busier for specialists on the topic. Some companies are cutting back on DEI initiatives while others are disbanding them altogether. Many more are quickly reconfiguring their policies, striving to avoid lawsuits from conservative activists as they attack diversity programs. That's led to a flurry of requests for audits from law firms and consultancies who specialize on diversity in the workplace. Take Kenji Yoshino, a constitutional law professor at New York University and one of the country's leading experts on DEI. He says inquiries from Fortune 500 companies have surged since June, when the Supreme Court banned universities from using race as a factor in admissions and opened the gateway for legal challenges to corporate diversity hiring practices. He's taking calls from a potential new client every week and estimates he's presented to about 75 companies since last summer. Quote, the appetite for this is just going through the roof, Yoshino said in an interview from his NYU office. It's exponential, and there's no end in sight. The executives are warning against conservative groups who, emboldened by the court's decision, have been launching lawsuits and complaints against diversity programs across corporate America. DEI initiatives, they argue, amount to reverse discrimination and must be legally challenged. Billionaires Bill Ackman and Elon Musk have joined the cause, further amplifying the backlash over these programs. Elon Musk tweets, DEI, because it discriminates on the basis of race, gender, and many other factors, is not merely immoral, it's also illegal. Jason Schwartz, who runs a DEI task force at law firm Gibson Dunn, said he's also seen a huge volume of demand for legal counsel. Quote, lots of clients are wanting to do audits, review all DEI efforts, board diversity, socially conscious investing, to assess risk and figure out what, if any, changes they want to make, he said. There is a never-ending tide of stuff. Public relations professional Lindsay Singleton, who advises firms on their communication strategy around diversity, says clients who were never interested in strategizing on DEI before are now clamoring for research and advice on messaging. Why they are so concerned about messaging? Because messaging is evidence. You put those statements out publicly, you make public statements, you're going to be held accountable for those statements in a court of law. Quote, companies are revising their DEI programs and looking at them with legal to figure out, how do we protect ourselves? How do we talk about it, says Singleton. There's a realization that whatever you say to an internal audience is going to be shared with external audiences because of lawsuit discovery. When you get sued, people get access to your communications. Still, though the legislative landscape is uncertain, Schwartz said that clients are looking for ways to continue their diversity efforts. Gibson Dunn is representing the Fearless Fund, a venture capital firm which is being sued over its grant program for women of color. But right now, you need a lot of creativity and tolerance for risk, Schwartz said. All the banks I've been talking to, their view is we're not going to overreact and abandon our programs. We don't want this place to look like it did in 1950. There it is. This is a total state of panic. We want to do it in a lawful way, but we're not going to run away from it. Bloomberg News asked DEI experts to help explain the connection between the Supreme Court decision on affirmative action and what's next. Answers are based on interviews with experts, including Yoshino and Schwartz, as well as articles written by law firms Duane Morris and Perkins Coie. Perkins Coie is where Mark Elias came from. Very, very political law firm in D.C. What's the connection between the Supreme Court's decision on affirmative action at universities and corporate America? What's the connection between the Supreme Court's decision on affirmative action at universities and corporate America? The decision by the Supreme Court in June doesn't have a direct bearing on employer policy, but it says a lot about where the court may go next. That's because rules governing discrimination in university admissions and in employment come from different parts of the same laws, the Civil Rights Act of 1964 and the Equal Protection Clause of the U.S. Constitution's 14th Amendment. Companies have been allowed to recognize race as part of their employment selection criteria under rules governed by the Equal Employment Opportunity Commission. These are codified as part of Title VII in the Civil Rights Act. And the EEOC said, under the Biden administration's control, that the court's June decision does not address employer efforts to foster diverse and inclusive workforces or to engage the talents of all qualified workers regardless of their background. Still, 2 weeks after the Supreme Court handed down its opinion, 13 state Republican attorneys general wrote to CEOs of the 100 largest U.S. companies, warning them that DEI policies could violate laws on racial discrimination. The letter confirms that the Supreme Court's decision could accelerate challenges to a corporation's DEI efforts, and that employers need to carefully evaluate whether their policies could face the threat of litigation, according to Gibson Dunn. Experts believe the court's views on race-conscious admissions will ultimately carry over in some fashion to corporate employment policies and have been advising their clients to bring their DEI programs in line. So which corporate programs are actually at risk? Yoshino says there are 3 criteria that can make a DEI program risky. 1, a preference for certain individuals over others. 2, when this preference is bestowed on a legally protected group, people of a certain race, color, religion, national origin, or sex. And 3, when a policy relates to a palpable benefit like a job, pay raise, or development opportunity. Though the exact boundaries may still be unclear, outreach efforts aimed at convincing more people of color to apply to positions aren't likely to raise red flags, but fellowship programs open only to minority candidates might. They will. Similarly, calibrating compensation around diversity with a specific team could raise alarm bells, while vaguer, company-wide goals might not. So if a company policy says a manager will get more of a bonus because they have a racially diverse team, or if a fellowship exhibits a preference for a protected group such as people of color, then it is legally perilous according to Yoshino. If a company has unconscious bias training for everybody at the firm, then that's legally safe because it's not directed at a particular group and everyone goes through it, he said. Unconscious bias training can be absolutely horrendous. And to even imagine they're selecting certain employees of certain races and telling them you need to go through some of this horrendous unconscious bias training because of your skin color is unbelievable. They actually do this in companies. I can't believe it got this far. When will we know more about what's legal? The Supreme Court may add a new wrinkle to laws around employment discrimination in June. It heard arguments last year in Muldrow versus City of St. Louis, a case in which a female police sergeant alleged that she was reassigned to a less prestigious role because she's a woman. The city argued that the transfer couldn't constitute a violation of the Title VII anti-discrimination law because it wasn't significantly harmful to her as it didn't result in a change of her pay or title. The sergeant argued that the treatment was still damaging and unlawful because it was based on her gender. The justices seem receptive to the sergeant's arguments, and people expect that she's going to win. The court may confine its judgment, though, only to job transfers. But external lawyers say a wider decision could put companies at risk of an array of reverse discrimination lawsuits for things that aren't currently deemed palpable benefits. For example, companies that offer mentoring or coaching opportunities only to members of a certain protected class, race, gender, ethnicity, might be at legal risk from someone who argues that not being included is damaging to them. Well, of course it's damaging to them. They're not getting free training. They're not getting a free benefit that other people are just because they have the wrong skin color. A very broad ruling could discourage employers from offering any development or retention programs specifically for women or people of color. Good, of course they shouldn't offer those programs based on people who are a certain gender or have a certain skin color. It's outrageous. Quote, as a practical matter, wrote lawyers for Dwayne Morris, companies should identify where every program makes such distinctions and either eliminate the exclusions or modify them so that they are not based on gender, race, or other protected characteristics. The diversity, equity, and inclusion nonsense has done great damage to the country. People have lost opportunities that they deserved. They were discriminated against. People have been given opportunities that they didn't deserve, which is also nonsensical because those people are not going to succeed in the long term in positions they can't do because they didn't earn those positions based on merit. All of this is returning back to normal, and it's definitely taking longer than I would like to see, but it is happening. We are seeing change. It is moving in the right direction. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another video. And if I don't see you, I will miss you.